Hello everyone. Whether it is the US, the GDPR or other privacy laws, most of them rely on the data subject's consent to data processing. In this video I will explain why this is not a good approach and draw mainly from a relatively recently published article by Daniel Solove in which he calls for murky consent. In the US, consent usually follows the notice and choice approach, which means that organizations publish a privacy policy which informs people about the data that is collected. That is the notice part. The choice part is that users may opt out of certain uses for that data, such as sharing their personal data with third parties, such as ad networks. Often it is an all or nothing approach, meaning that you can either consent to all of the data processing or not to do business with that organization at all. This approach has faced a lot of criticism as it is common knowledge that no one reads privacy notices and those who do don't understand them. Even if you wanted to, there are just too many privacy policies to read. As a result, hardly anyone opts out of data processing, which in turn leaves notice and choice as a paper tiger that doesn't do anything to protect personal data. In the EU, the GDPR follows the express consent approach, similar to the recently discussed DPDP in India. In both regulations, consent is one of the lawful bases which have to be met in order for data being collected, meaning that instead of consent, another legal basis can be met, for example processing data that is necessary to fulfill the contract between the data curator and the data subject. If consent is given, companies need to prove the fact, and it is only given for a specific purpose. On first glance, this approach seems superior, however it has many of the similar problems that notice and choice has. It is obvious that consent is only meaningful if people know what they're consenting to, which means that consent must be informed and voluntary. This is, however, very often not the case. For notice and choice, silence is often interpreted as consent. This also extends to not changing a pre-ticked box that says I agree. You have no way of confirming consent in this case, as you simply don't know whether the data subject actually looked at the privacy notice or at the thing he agreed to. It is worth noting that this is one of the reasons why the GDPR prohibits pre-ticked boxes as means of obtaining consent. But back to the US, legally speaking, the person ignoring an I agree checkbox consented to data processing. So notice and choice neither notifies nor does it leave any meaningful choice. Express consent, what is practiced under the GDPR, means that data subjects actually have to click something in order to consent to data processing. However, this is only marginally better since the vast majority click I agree anyway, without reading privacy notices or without clicking. In fact, clicking the I agree box only increases the readership of privacy policies by a staggering 1%. It is common knowledge that people click have read and accept without actually having read anything. It is a privacy theater we all participate in. I am certainly no exception to this. Strangely enough, legally, those things count as consent. Again, even though everyone, and I mean everyone, knows that no one actually consents. So it is worth asking whether this consent is actually voluntary. Consent in the US is often a take it or leave it approach, meaning if you want to use a certain product, you have to consent to all the privacy violations that might come with it. You might argue that you can leave it and thus your consent is voluntary. However, very often you do not find adequate alternatives and you would have to plug out from the modern world in order to not fall prey to this practice. A contract between a normal citizen and a multi-billion-dollar enterprise is hardly eye to eye, and most consist of unilateral terms offered by the contract makers and have to be accepted by the contract takers. Under the GDPR, consent has to be freely given, which is better than the US alternative. The GDPR also protects vulnerable groups such as children or employees against employers who have leverage over them. However, the GDPR does not extend this protection to everyday people, and thus, as a consequence, consent is as involuntarily given as in the US. Privacy notices are ripe with manipulation attempts. These are right between persuasion and coercion, often falling on the latter. A common terminology used in this regard are dark patterns, manipulative and deceptive interfaces, and attempts to obtain consent. Privacy laws try to address these issues but can naturally only address the worst forms of it due to people unfortunately being manipulable. People are also gullible and behave irrationally, which can be exploited if you know how. This is why privacy law will probably always fail to protect against obtaining consent in a manipulative way. If consent is a precondition to using a service, then it is hardly voluntarily given. Another common practice is to pay or consent, which is used for ad cookies which are not placed if you pay for a subscription, for example. However, obtaining and selling data is the business model of the internet, which is why you presumably are not paying to watch this very video. In return, your data is used to make a profit. That is why privacy laws don't apply here. The CCPA explicitly states that organizations can charge more if users don't share the data if, quote, that difference is reasonably related to the value provided to the business by the data. It is a question of autonomy and agency. Do people realize what they are giving away in exchange for all the free services on the internet? That's at least questionable. The GDPR regulates that more strictly, stating that consent that is given because it is necessary for the contract is not considered freely given. However, by cleverly framing contracts, organizations can avoid this problem. Next, we move on to whether consent is really informed. I already mentioned that privacy notices are hardly ever read, and even if they are read, the legal jargon makes them hard to understand. There is nothing in the regulations that ensures that consent is actually informed, because reading the privacy policies is not mandated. Imagine putting a quiz of the privacy notice instead of an I consent box. You would have exactly 0 people using a product. There are some approaches to this by using nutrition label-like indicators regarding the data you collect. In various app stores, you can also sometimes find a distilled list of data that is collected by a certain app. This is definitely the right direction, as users can see at first glance which data is collected and whether these collections are even necessary. For example, why does a calculator need to know your location? In the grand scope of things, however, this is not a solution, as the amount of data collected and how it is used is too vast for a couple of icons. As an example, you would have to understand how the company stores your data, what encryption schemes they use, which cloud providers they use, are they ISO certified, is there even a security team in the company, and so on. You have no way of finding out all of that, even if you're interested and even an expert in this field. Laypeople stand no chance and end up consenting to bold statements that data is protected and that your privacy matters to us. They neither care nor have any chance of understanding how the data is actually protected. Also, individuals don't know what companies can actually do with their data. Secondary use and data inference are things that are distant concepts at best for most people. Insofar, consent cannot be informed since people simply don't know enough about modern data analysis. Even experts such as myself and, of course, Daniel Solove struggle to really understand whether data sharing is now adequate or not. The only difference to laypeople is that we often know that we don't know enough. People tend to overvalue immediate benefits compared to future costs. This is a common phenomenon and is even more prevalent if these costs are not really concrete, such as is the case with privacy violations. This is an obvious problem if they consent to privacy notices, which give immediate access to the desired product or service with only a faint lurking privacy harm which might or might not materialize in the distant future. I have talked about this in the beginning of the video, that privacy regulations in the US often follow an all-or-nothing approach. This is an obvious problem, and I discussed this already. However, the GDPR, on the other hand, overwhelms people with too many choices, which is an obvious problem on the other side of the spectrum. According to the GDPR, a data subject has to opt in for each new purpose the data is used. The cost of this overabundance of privacy choices is the so-called privacy fatigue or consent fatigue. People tend to not care very much if they are asked every other second about their privacy preferences. So now that I've told you the myriad of problems existing with privacy law and consent today, how do we solve this? Daniel Solove's approach to this is called Murky Consent, which I will present to you right away. The name Murky Consent stems from the fact that it exists between full consent and non-consent. It is purposefully called that to give adherence to the fact that consenting to privacy regulations is not full consent, but a fiction everyone more or less plays along with in order to make the digital economy work. Murky consent has on purpose less legitimacy than current full consent, whether it's notice and choice or express. In the digital world, consent is not a black and white decision, but rather exists in the ambiguous zone in between. Murky consent aims to take this fact into account and thus provides less legitimacy to given consent, than full consent does. In practice, this would mean that even though the user consents to data collection, the organization should still not be allowed to collect whatever the user unwillingly consented to. Rather, consent should provide the organizations with a limited and highly restrictive license to gather data. If people consent to objectively bad deals, these deals should not be treated as legitimate. Therefore, murky consent grants organizations less power than full consent does. This means that if reasonable expectations are not met or unreasonable risks are taken with the user's data, consent should become void. In summary, murky consent addresses the fact that we all play privacy theater with consent. It acknowledges this fact and tries to give consent a reasonable and realistic spin by saying that consent is probably never full consent. And if it is, you should make sure that the other party knows what it consented to. Otherwise, consent should be treated as murky, meaning that it doesn't have the power it had until now. To me, it sounds like an interesting approach to a very real problem. Let me know what you think in the comments, and I'll see you in the next video.